Oh, sure. We were looking at time of 2:30.
Yeah, that's a ish.
Okay, that's fine. Okay. Do you want copies of the cases that are in my outline? They were emailed in. I don't want to burn
This can't happen. I'm going to raise some issues and...
I understand. I just want to know if you would like copies of them. Like hard copies.
This can't happen. This is clearly a judicial abuse. I mean, what have we got? 500 pages of Facebook.
Unless they put it in here while I wasn't here. Is that it?
Boys, this is... We're here for
They didn't tell me.
the human rights abuses that we've been... Wow. Looks like we're...
So it's all right. Court is reviewing. Please proceed.
The matter of Harvey Day Boat Club Incorporated and ERSKINE filed 3328 October 25 for application hearing.
May I please report? My name is Delucchi, D-E-L-U-C-H-I, initials R-M, instructed by Mullins lawyers on behalf of the applicant.
my name's Erskine, initial A. First time here, hello.
What's this about?
Your Honour, the hearing today was originally the hearing of an originating application filed by the Boat Club. The application concerns a breach of a non-disparagement clause, and the applicant seeking some injunctions to enforce that. What's become apparent in the days leading up to today is that the hearing of that originating application will take longer than 2 hours. So what the applicant has proposed today is that the matter be adjourned to the civil list for a hearing. But we are seeking an interlocutory injunction. The purpose of that injunction is to restrain the respondent from posting further material online, and that material is the subject of the main application.
Right.
So there was an interlocutory application that obviously the registry didn't accept it in the day leading up to today because the application was withdrawn. But what we're asking you for today is to hear our interlocutory application in place of what was originally listed, which was the full hearing of the originating application.
What material do you read for today?
Well, I might hand up to your Honour at 10 minutes two copies of my outline, which has a list of material in it. I'll also give you on 2 copies of the draft order that we're sitting on, and a copy of the interlocutory application. And I'm going to give a copy of that material.
Thank you.
And can I just say this at the outset, Your Honour? The 2 affidavits of Beatrix Roy and David Clinton have quite voluminous exhibits. 95% of those exhibits are Facebook posts. It's not necessary. We're not asking you to read all of those exhibits. What I've done in my outline is I've put some extracts from the published material at page 12 of my outline, which will give Your Honour a flavour of the types of publications.
So this application, is that the interlocutory application or is that the...
Today we're asking, that's the interlocutory application.
that's the one dated 23 September 2025.
Yes, is that one?
And so you need leave to read and file that application and leave to file your outline of argument.
Thank you.
So
Yeah. First, I have to apologise. I haven't slept for 2 nights, and I'm really struggling right now. There's some very serious matters that I wish to raise.
sorry, just bear with me. Have you got any material, any affidavit or anything you wish to rely upon for purposes only of today?
Yes, but I don't think we shouldn't be going that far even. I can email them through.
No, I just want to, just so you understand what's happening today, is the nature of what has been said to me by counsel for the applicant is that today is very much an interim hearing. It's not the final hearing, it's not the hearing on the merits. And ordinarily on that type of interim hearing, the court ordinarily looks to preserve the status quo pending the determination of the application for final relief. Now, as I understand it, what the boat club, if I call it that, is seeking is that in the short period of time between today and when this matter will be heard, there is effectively an interim, not a final, but an interim order put in place which precludes further publications of material. And that would have to be on the basis that the boat club gives you an undertaking, the usual undertaking as to damages, that is, to the extent that that causes you any, are you offering the usual undertaking?
Yes, Your Honour.
Have you explained that? Has anyone spoken to Mr. Erskine about the undertaking?
We haven't discussed the undertaking.
Right, that just means that the price of preserving the status quo is that the boat club gives you an undertaking to pay any damages caused by the interim order pending the final hearing.
Thank you, Your Honour. Can I make a few points that are very concerning to me? I've been locked out of all the process leading up to today. The court audio I've obtained from the last hearing, it appears that false affidavits have been filed of service that don't align with anything that I understand to have occurred. Documents have been served very late, leaving me at clear disadvantage. And Your Honour, I'm not unwise to why we're here. There are some significant legal issues and conflicts, and this goes to the very heart of human rights and what we've been through as a family. There's a number of concerns in the affidavit that I've had to prepare very quickly. We've had commissioners such as Karen Carmody interfere with our family law case to the point where my daughter was suicidal for a year, cutting herself, hospitalised, and I'm a bit concerned that no one's disclosed the interference of the Crime and Corruption Commission between June and September 2021, and our local member having his tenure on the committee terminated. This is effectively an application by David Hinton, who is my family lawyer. He's the only employee of the boat club who has signed an affidavit. He was my family lawyer, who has broken my family as my family lawyer and destroyed my daughter. I've prepared an affidavit where my daughter was having medical treatment suppressed from her. I've got the transcript from the doctor in my affidavit. And this was being suppressed as per the court transcript I've got from the Federal Circuit Court of Australia, that we had David Hinton, who was also my employer at the boat club, this legal conflict that was also withholding my daughter's hospitalisation and self-harm from a Federal Circuit Family Court hearing. My daughter had sepsis. This is not an unpolitical motivated. Karen Carmody was a commissioner who was appearing for my ex-wife and misusing that jurisdiction on a number of occasions to move evidence, basically launder evidence. And we can't get transcripts. So we have a disclosure issue. I'm here in a court. I still can't get transcripts from where Karen Carmody, I believe, was committing criminal offences. And it's in my affidavit where I can't get audio from a Queensland courtroom, which started leading to daughter attempting suicide. This is an application by my former lawyer who is withholding legal documents from me. On the 18th of June this year, I emailed him and asked him for all my files, including my deceased father's files. Professor Wayne Erskine, every aspect of his death is fraudulent. I have a father who David Hinton was looking after the estate. There's 2 death certificates. Everything's fraudulent. And on the 18th of June, he's flatly refused to give me my father's legal file. And here I am now being subjected to an application from the boat club, who is also my former employer. It also concerns me that Pat Mullins is the current Police Review Commissioner, and my family have already been affected by significant corruption, to the point that in 2021, my daughter was hospitalised by the treatment of a number of police officers, including Chris O'Brien. We have such significant conflicts here, with Karen Carmody involved in our family law matters, David Hinton involved in our family law matters, the boat club as my employer with David Hinton on the board, David Hinton responsible for my unfair dismissal, where all things considered he was trying to derail my life before we got to the November 21 family law trial, which was also when my daughter was suicidal and cutting herself and developed sepsis. So just give me one moment. When I signed this deed, I've got recordings where they're telling me to effing sign it, effing move on with your life. You got to think about this how they want you to think about it. I've got these recordings. My daughter was in hospital with intravenous drips, with sepsis because of self-harm. My youngest son had developed rashes around his mouth from nervous conditions. I myself was lying in bed crying for days on end because I didn't know what we did, any of us, to deserve any of this. With this process, I've been shut out. They didn't try serving me for 2 weeks on anything that I can find. I was contacted once, and that was late at night. I live on a rural property. The driveway's 150 metres long, and we are scared. Someone contacted me late at night. As I said, for our safety, I'm not coming out late at night for someone who says they want to serve me something. And this...
Mr. Erskine, can I just interrupt you for a moment?
Yes?
If you're not feeling well, you can sit down if that makes you feel better.
Thank you.
I just want to, my job today is to manage this. It's not to make a decision vindicating your position or to vindicate the boat club's position. Do you understand that? You're not going to leave, the boat club's not going to leave court today subject to this, what I'll call this interlocutory matter we need to try and make a decision about. But in terms of the underlying merits of whatever dispute there is between you and the boat club, we're not touching that today. But what the boat club is saying is this. There's been some publications that you've authored that they're complaining about. They want to go to court about that, and you'll have your right to fully ventilate whatever you want to say about that in court. But pending that court hearing, which I'll have to hear from people about as to when that can occur, the boat club is just asking for this court to make an order that effectively prohibits any further Facebook publication or publications derogatory, just until the hearing, derogatory of the boat club. Do you understand that?
Yeah, can I?
Now I think you need to think about that, as to whether you are, what your position is, but that's what the order the Boat Club's seeking. Have you shown the draft form of order to Mr. Erskine?
Yes, Your Honour.
Or when did you show that to him?
I beg your
When
pardon?
did you give him a copy of it?
Before Your Honour came in this morning, this afternoon.
Alright, so he needs to have a proper chance to read that.
A what?
The draft order. Is Your Honour referring to the draft order?
The order you seek.
Yes, it was in, Mr. Erskine has had a copy of the application and the outline of submissions, which also sets out the orders we're seeking since yesterday.
Right, but alright, so I just need to focus on the order at the moment.
I need to make a submission, Your Honour. If that's
Yeah.
the right term. Your Honour, I can prove that the Boat Club has inflicted such long-term human rights abuses on my family. While David Hinton was my lawyer, the Boat Club had other IT people, where I was the IT manager, monitoring my entire life 24/7. I had no independent access to anything legal. I had nothing private. I had nothing personal. I've had my son snatched. We've been subjected to relentless, malicious prosecutions. I've got, I think it's 8,000 recordings of these people that have come to my counselling sessions to try and convince my counsellor that I'm crazy. Your Honour, I know what the evidence is. We've been subjected to relentless human rights abuses.
I can't make any decision about this today. I've tried to be patient with you and say today is not about me. You keep looking at the two gentlemen in the back of the court. I presume they your sons?
Yes.
Well, I'm just going to say this for your benefit. I'm not today making any decision about the merits, whether your position is correct or the Boat Club's position is correct. It's not the time for it.
You don't understand what we've been through. My daughter's isolated from me right now. I'm the primary carer. We understand what this pattern of behaviour is. This isn't the first time this has happened. This has happened because I have been preparing 8 cases. I'm trying to arrange an inquest into my father's murder. My brother's murder. This is a hit. I've been working day and night for 6 months, preparing to deal with my dad's murder, my brother's murder, our malicious prosecutions, the slices up and down my daughter's arms. This should be heard in the High Court. There's been state commissioners that have interfered with our family federal jurisdictions. This can't be heard. I'm not a lawyer, but there is so much state interference, particularly with our family law matter. I'm worried about my daughter now. This needs to go to the High Court. And this has only happened because I asked for legal files of my dad. My dad.
Let's ask you this, please, Ms. Galucci. What the publications of which you're seeking to
Yes.
when was the most recent one?
Please watch the video of my son being snatched. That's a human rights matter. You can't undermine that. Obviously, I'm on the right track.
In Ms. Wanroy's most recent affidavit, which is court document number 12, Your Honour, all of those posts were made in the last 2 months. The last was on the 6th September 2025.
ones extracted in your outline, do they have the dates or?
The dates are not in my outline, but the footnote references are to the affidavit material. It's a very small selection that's in there. They go.
Now, you want this matter listed in the civil list? It just doesn't seem to me that if I gave you a day in the civil list, well, what's that? Is it actually going to be able to be run on that day? Because it just seems to me like, how do you understand a day in the civil list is going to be used?
Well, after today, Your Honour,
There is a list in this court for supervising self-represented litigants.
yes.
I'm not sure if you think the matter would benefit from management or whether, from your perspective, that if the matter was listed for a one-day hearing in the civil list, whether you expect that you could actually make submissions and Mr. Erskine could make his submissions and rely upon his material. I'm not sure what the state of where he's at with his material, for instance.
I'll let Your Honour know we haven't received any file material from Mr. Erskine.
I think Mr. Erskine's indicated that there's some material that he wishes to rely upon.
Yes, he's given us an unsworn affidavit this morning. I take it on this point, and I would like to take some instructions about whether that supervised list might be more.
Well, it just means that Mr. Erskine then knows that the court will provide its supervisory powers in aid of this matter, and if he wants to put on material, he'll get the opportunity to prepare it in a structured way.
Yes, I think that perhaps would be of benefit, Your Honour, because after today and my discussions with Mr. Erskine,
Mr. Erskine's obviously very affected deeply by this,
yes.
and
My kids!
And he's said at the start that he's not in a very good way, which so that it just seemed to me that if I gave a trial date in the near future, I'm just not sure that trial date would be able to be utilised. So.
Yes, I take it on this point, and I tend to agree with you, but I'd like to just.
Well, can you take those instructions on?
Yes. Yes, my instructions are clear. Thank you.
All right. Now, you said you offered the undertaking. Your order doesn't reflect the usual undertaking.
I'm sorry, Your Honour, because it was a last minute addition. I have a copy of the undertaking if that exists, Your Honour.
Right.
And perhaps we can just hand it in as the order that I've handed up to you. Your Honour, could I just respond to one thing that Mr. Erskine said about the service of documents? The originating application and supporting material had to be served by way of substituted service because we weren't able to serve Mr. Erskine personally. They were served pursuant to the orders of Justice Wilson in a substituted service manner.
Right.
I have a number of concerns with the court audio of the last hearing.
Sorry.
I have a number of concerns with the court audio of the last hearing.
I was at the last hearing, so
Yep.
that's a matter you're not.
Nothing that is in that court audio, such as me not contesting, there's a claim that I wouldn't contest the application. There's also a claim that I signed the deed freely.
Were you at the last court hearing?
No, I obtained the audio after the
Were
fact.
you at the last court hearing, Mr. Lucci?
Yes.
The substituted service application, I appeared at.
Right,
so
well,
that's
just you might listen to this in case you need to respond to anything.
yes.
Yes, because you are in that audio saying that I signed the deed freely. They were 2 years into. I thought it was. Your Honour.
I think the last hearing has only been directed to how you would be served. It hasn't decided any issue in the case.
Yep.
So you're not burdened by anything said at the previous hearing.
Your Honour, if it helps you, I've been for the last 6 months trying to find out why we've had no access to basic human rights. And I've made a lot of ground. My father, Professor Wayne Erskine, the last time I spoke to him, he said he had a treatment intruder the night before.
He had a what the night before, sorry?
An intruder.
Oh,
My dad didn't. My dad was disposed of. And Mr. Hinton is still holding files. My life is about trying to keep my kids safe. My father, Professor Wayne Erskine, he was described as having a monumental brain. He was seen as a bit of a political nuisance to a number of big schemes.
Mr. Erskine, I think at the moment the submissions you're making aren't really related to the particular matter I'm dealing with at the moment. So I'll just ask you to sit down at the moment, thank you.
This is a human rights abuse.
I understand that's what you will allege. Can I just ask you this? There's a Harley Bay Bike Club, and there's an undertaking given here by a secretary on behalf of the applicant. Does the applicant, that's an incorporated association, is it?
It is an incorporated.
Does it have any assets or?
That's freehold.
I can't answer that on my feet, Ron. I'll have to.
I can answer that, I used to work there.
I'm sure I can get those instructions.
No, just so, it's just that it's an undertaking offered by a natural person on behalf of an incorporated association.
Yes, Your Honour.
For that association to pay any, effectively any damages caused by the interim order.
There's certainly no suggestion that it's a pecunious association.
Alright,
It's currently trading.
now your submissions in support of the interim order, are these submissions directed to the interim order?
Yes, Your Honour.
Is the deed in evidence?
Yes, it's in the first affidavit of David Hinton.
And is one of the issues that, as I understand, Mr. Erskine will raise is that he's signed the deed under duress?
That's just arisen today, yes, Your Honour.
Well, I'm sorry. One of the issues that he will raise in relation to the deed is that it's not binding upon him because he signed it under duress.
That is what I understand him to have said.
I can play, sorry to interrupt, and I'm not going to do it right now, but I've got recordings of me being told, sign the fucking deed, sign the fucking deed.
Mr. Erskine, just we're in court. Can you please mind your language?
Sorry, I was doing it verbatim, sorry, it's what I was...
There's other people sitting in court.
I apologise, I don't normally speak like that, I was just doing it verbatim because that's how I was spoken to.
Is the deed itself the deed?
Yes.
Of what? Termination of someone's employment? Or,
Essentially, yes.
and is the employment Mr. Erskine's?
Yes.
Arranged by my lawyer. The whole thing is illegal.
The relevant clause of the deed is set out as paragraph 6 of the outline.
Yeah. Can you tell me the footnote, the material that's referenced in footnote 17 of your outline?
Yes, Your Honour. Takes up the affidavit of David Hinton, court document 10.
Thanks. You can sit down, thanks, Mr. Erskine, you're turn now.
Here.
Yep. Yes.
So there are a few page references there. The first is 17. Actually, 17 of the exhibits.
No, it must be the wrong one, sorry. The affidavit of David Hinton, doesn't it?
Oh, I beg your pardon, no, it's not court document. Oh, I'm sorry, it's court document 3. I'm very sorry.
And then that conversation. We'll talk about 3, thanks. Thank you. Yes. Call file next one, or 3. I've got that.
Yes. So there's a statement in that publication where the respondent says he's prepared to go public with his experience and
Where, sorry?
about halfway down.
Page what?
Oh, I'm sorry, page 17 of the exhibits.
Yeah.
So this is this is one publication that was made by email. Most of them have been made on Facebook.
I don't even know if these are my publications. What are we looking at?
Looking at it's this affidavit being served,
Yes,
but under the substitute service regime. So,
I'll get a copy.
so the physical copy is not actually provided to Mr. Erskine when he came to court.
No, Your Honour.
Right.
It's quite clear a few things aren't being done right.
No, that's not correct. I'm just trying to find, you're ordered to be serviced under the law for substitute service. I'm just trying to see what you've got. So you're taking me at page 17 to an email sent to the board, for your case on Mr. Erskine.
There's a number of...
Actually, this, is this sent in 2021?
This particular one is,
Yeah.
yes.
What?
Well, sorry,
I'll bring you something.
there must be more contemporary evidence where there's a threat to continue to engage in the conduct.
Yes, Your Honour. Can I bring it?
Mr. Erskine, as it was, the lawyers for the boat club are looking for this material, you do understand that all that's being sought today is an interim order by which you are restrained from effectively disparaging the club until the court can hear from the club and hear from you. Are you prepared to abide by that type of order?
I would love to, Your Honour. I've only felt I've needed to do this because it was the club itself that was doing this to us.
But the point is you've engaged in conduct. There's, as I understand it, the club's case is that to date you've published a number of things and said a number of things about people at the club and the club. So that can't be dealt with today. You've made publications on Facebook and the like. The question is going forward, until the court can deal with this in a merits-based way,
Yep.
are you prepared to abide by an order of the court that you not engage in further publication?
You know, I'd love to. Yes, absolutely. And I give you that undertaking. And I just ask that return that we're safe.
All right, Ms. Bellucci, I think what's happened is that Mr. Erskine has indicated that he's prepared to consent to an order that I think the way it should be framed is that neither side disparage each other. Do you understand that?
Yes, yes.
So rather than making it an order imposing only an obligation on Mr. Erskine, I think the appropriate order by consent of the parties is that until the final hearing of this matter, the applicant and the respondent shall refrain from making or causing any publications or communications as set out in your draft form of order. Do you understand that?
I do understand.
And that way there won't be an undertaking as to damages. It's a consent order where there's an obligation placed on each side.
I understand. May I have a moment to take some instructions
Yes.
just to confirm that?
what Mr. Erskine said effectively, and I know you do not accept this, but from his perspective he's saying protection for his side, that way there's mutual order, and I think that achieves that object. And I know that you do not for a moment accept anything that's been said about your client.
Yes.
Do you understand that?
Thank you.
So then in terms of taking the matter forward, I think the matter should be placed on the list for the supervised list for self-represented litigants.
Yes.
And what that means is that there won't be a hearing date allocated, but the associate for one of the judges who supervises the list will contact Mr. Erskine and your client for the purpose of just a review hearing. That'll be just when you come in and tell the judge what needs to be done, what needs to be done to further progress the matter.
Yes.
Now, what was the applicant? What were the documents that brought this hearing before the court today? I need to know what's the document to adjourn. What document needed?
It's the originating application, Your Honour.
And is that the one filed on the 30th of July?
Yes.
Right. Thank you. So the orders I intend to make, which I've made now, are as follows. Mr. Erskine, you may wish to listen to these orders.
I'm listening. You're on. Yeah, I am.
Thank you, Mr. Erskine. The originating application filed 30 July 2025 is adjourned to a date to be fixed. The proceeding BS 3328 of 25 is placed on the self-represented litigants supervised list. Until the final the third order, which I note is an order by consent. By consent, until the final hearing of the proceeding, the applicant and the respondent are restrained from making or causing any publications or communications, bracket online or otherwise, bracket of a disparaging nature, concerning the respondent or the applicant or any individual or entity who is a past or present director, past or present officer, past or present employee, past or present servant, past or present agent, associated entity or related entity or related body corporate, as those terms are defined in the Corporations Act 2001, bracket CTH, bracket subsidiaries, successors and assigns. The costs of today's proceeding are reserved, which means there's no order as to cost made today.
Your Honour, the form of the mutual non-disparagement in the deed is slightly different.
Right.
In respect of the obligation undertaken by the club, in that it's directed only to Mr. Erskine and none of the associated.
No, well, the intent of the order I just read out was that your client will not disparage Mr. Erskine.
Yes.
And Mr. Erskine will not disparage your club or the extended
Thank you, Your Honour.
definition of your club.
Thank you.
You understand that?
Yes.
And that's now my associate will do up that form of order. I'll initial it and I'll provide it to the parties, and the next communication you'll receive will be from an associate of one of the supervising judges.
Thank you, Your Honour. There's just one further matter, which is the most appropriate address for service for Mr. Erskine.
Yeah,
We've got quite a few email addresses.
Well, I'll see if I can deal with that.
Thank you.
So at the moment, Mr. Erskine an order was previously made saying that you could be served, if necessary, with material by the boat club by a process of substituted service. Now, it would be better, I think, for you and for the boat club if you could, for instance, if you have an email that you're prepared to accept documents at, if you could identify that email.
Yep.
And that way the boat club can, rather than have the situation where they're attending a substituted service, if they want to serve you with something, can send you an email for the attachment. Is there an email that you have in mind?
It's normally my own hosted one, but it's playing up, so I'm going to use aaron.erskine@outlook.com. I'm having my own server issues.
So aaron.erskine@outlook.com. So I'll make a directional order that for the purposes of service requirements in this proceeding, the respondent's address for service shall be that email.
Thank you, Ron. And is it appropriate that I take back that undertaking
Yeah.
as well? Thank you.
Do you want those copies or?
Yeah. Sure.
I think the other thing I'd like to indicate to your solicitor is that to the extent that you have served anything by substituted service to date,
Yes.
it may be appropriate to, if you've got that documentation in court today, to physically give it to Mr. Erskine.
Yes, we've just done that.
So he knows.
And apologies for
So
that.
Mr. Erskine. So at least when Mr. Erskine leaves court today, he's actually got the physical document.
Yes.
All right, thank you. Is there anything further?
No, thank you.
Thank you.
I don't think so. I want my brain shut down.
Thank you, Mr. Erskine. Thank you, Agenda Court.
Silence all rise. The court is adjourned.
These are all of the court documents that we've filed so far, and I know it's a bit bulky, but they're tagged, so they're on.
Yeah.
Yeah. Yeah. Okay. Just so that you have everything in hard copy.
It's just what I have is a bit.